So without further ado, I will go into my respondent argument, and this is for issue 2, which was around the First Amendment. May it please the court. My name is Anna Kavulla, and I will now respond to the brief regarding Mr. Danoff's First Amendment constitutional rights at the case at bar, Danoff versus State of Olympus. Today I'll be providing you with 2 submissions, urging this court to confirm its previously determined decision of a guilty verdict of Mr. William Danoff on the charge of involuntary manslaughter. The first of these submissions being that the communication to Bronner by Danoff here was directed to incitement as it produced a lawless imminent action, as it posed a clear and present danger of violence. And secondly, Danoff's lack of action, as he openly admitted to Olympus police that he was present at the time of death and did not intervene but alternatively continued to incite Ms. Bronner to take her life. The petitioner argues that his conviction of involuntary manslaughter violated his right to free speech under the First Amendment of the United States Constitution. We disagree and find that no constitutional violation results from convicting a defendant of involuntary manslaughter for his reckless and wanton conduct, in addition to the pressuring text messages that preyed upon the well-known weaknesses, fears, and anxieties that finally overcame the willpower to live of a mentally ill, vulnerable person, thereby caressing her to commit suicide. Olympus Public Law 417, as noted on page 2 of the case brief, states that involuntary manslaughter is defined as causing the death of another unintentionally by an act which constitutes such a disregard of probable harmful consequences and amounts to wanton or reckless conduct. Now, the Superior Court noted that this case is complex, and at a seminal level, the issue boils down to where the line is drawn between advocacy and action, and cites Brandenburg v. Ohio. In this case, it found that the Ohio statute punishes mere advocacy and is therefore in violation of the First Amendment. The court held that the government cannot punish speech unless it is intended to incite imminent lawless action, and a 2-pronged test was created to evaluate the constitutionality of laws restricting speech acts. Firstly, speech can be prohibited if it is directed at inciting or producing imminent lawless action, and secondly, if it is likely to incite or produce such action. Now, applying this test to the case at bar, Mr. Danoff incited Ms. Bronner to take her life, and the said action occurred. The petitioner suggests that because suicide is not against the law in the state of Olympus, that there was no imminent lawless action. But we strongly disagree and note that Danoff advocated for Bronner to take her life, as seen in Exhibit B of the portion transcript. In this, we see over 47,000 text messages that were sent. In these, he incites Ms. Bronner to just do it, get it done, the world would be better off, and go die. The chat messages at issue here were directed to incitement and produced an imminent lawless action as it posed a clear and present danger of violence. Now, this line of thought is legally consistent with the ruling of Rice v. Paladin Enterprises. Now, in this case, the court found that speech that is integral to criminal activity is not protected merely because it is speech. Extortion, blackmail, and harassment may be criminalized by law, even though they typically all involve speech. Likewise, conspiracy to commit a crime is not protected in association with the First Amendment. Now, the court also acknowledged in the 2022 case, Counterman v. Colorado, that the proof of all mental states of parties involved would be needed to address the theoretical advocacy deemed worthy of First Amendment protections in other cases. Now, Ms. Bronner is by all accounts suffering from mental illness. She was diagnosed with depression in high school following a failed suicide attempt. Mr. Danoff, on the other hand, is described on the case brief on page 3 as one who is described by friends and family, the very people closest to him, as being very controlling, tracked her whereabouts all the time, and was both verbally and psychologically abusive. Now, in the Counterman v. Colorado case, we see a very similar situation occur to the case at bar, when the petitioner repeatedly contacted a young woman over Facebook, sending her messages that were deemed creepy. Now, in this case, this court charged him with stalking due to the inflicted harassment and emotional distress. Now, the case at bar goes well beyond this, as Mr. Danoff caused Ms. Bronner such harassment and emotional distress that led to her suicide. Now, in addition to Mr. Danoff's reckless and wanton conduct, we see that he also did not take action to prevent Miss Bronner's death. What is overlooked in this case and in the petitioner's argument is the small sentence found in the case brief, page 3, paragraph 1, line 10. Mr. Danoff admitted to the Olympus police that he was present at the time of her death. The crime at issue here is directed at a course of conduct rather than speech, and the conduct it prescribes is not necessarily associated with speech. The petitioner cannot escape responsibility simply because he used words to carry out illegal actions. What is missing from page 2, paragraph 2, line 10, is that Mr. Danoff did not intervene to prevent Miss Bronner's death, but alternatively continued to incite her to take her life, as seen in Exhibit C of the portion transcript. And the statement that he made to police was that he was just trying to help her visualize her death. Danoff's conduct and his decision to not intervene as Miss Bronner took her life is not a free speech protection granted by the First Amendment. The petitioner at times has also looked to the Watts v. United States case in attempts to gain legal traction for their argument. Now, in this, the Watts court found that speech that involves a true threat, in this case at an anti-war rally, falls beyond constitutional protection. Now, true threats lack First Amendment protection because the purpose is to cause injury rather than to add to or comment on the public discourse. Now, in this case, it is hard to argue that the consistent and repeated exhortations to kill oneself, which in fact did lead to the said result, were just mere philosophical discussions or that they didn't pose a true threat at all. Now, one other case that warrants serious legal considerations as it pertains to this case is the Waller v. Osborne case. Now, in this case, the circuit court found that the singer Ozzy Osbourne could not be held liable for suggestive lyrics found in his music that led to the suicide of a listener. Implementing an incitement to imminent unlawful activity test, the court found that the issue involves whether the speech is directed at a specific person, whether it advocates for specific action, and how likely that action is to result in an imminent unlawful action. Now, applying this test to this case, we see that Waller was not targeted in the lyrics, and as such, Osbourne could not be held liable for the suicide. But on the other hand, if we apply this test to the case at bar, we find the opposite to be true. Danoff's words are directed to a specific person, in this case Miss Bronner, and it specifies a specific action, in this case suicide, and then that would result in an unlawful action of involuntary manslaughter because Danoff had reckless and wanton conduct that led to the death of another. In conclusion, we agree with the majority of the Superior Court of the State of Olympus. Danoff's messages were not discussions to contribute to the public discussions of suicide or suicide prevention. His messages were shared with Bronner on a private app, and the messages were clearly designed to play on her insecurities in order to make her feel that her life was worthless. There can be no doubt that given its interest in this area, the state can punish Danoff accordingly. He may also find no refuge in this court for his deliberate and callous acts. For these reasons, we urge this court to confirm the decision of the lower circuit courts and find that Mr. Danoff's First Amendment constitutional rights were not violated. Thank you.